Is prima facie evidence enough for a preliminary hearing? Imagine standing in a courtroom, hearing the judge call your case, and wondering if the evidence against you is strong enough to move forward. That's what a preliminary hearing is all about. It's a key step in navigating the criminal justice system before a trial begins. But what exactly does the prosecution need to show at this stage? And does having what's called prima facie evidence mean your case is solid? Let's break it down. Prima facie evidence is the initial proof the prosecution must present to justify moving the case forward. It's not about proving guilt beyond a reasonable doubt. That's for the trial. Instead, it's about showing enough evidence to support each essential part of the crime charged. For example, if someone is accused of theft, the evidence should suggest that theft likely occurred and that the defendant was involved. The prosecution doesn't need to have all the facts or prove guilt yet. During the preliminary hearing, the judge's job is to decide if there is enough evidence to hold the case for trial. They don't weigh the evidence deeply or judge credibility. They simply look at whether the evidence presented could lead a reasonable person to believe the defendant committed the crime. If the evidence meets this standard, the case moves forward. If not, the charges might be dropped or reduced. From a defense point of view, this means even if the defendant has strong evidence of innocence, the case can still proceed if the prosecution meets the prima facie threshold. The hearing is not a trial, so it's not about proving guilt or innocence. It's an early screening to prevent baseless charges from wasting court resources. It's also worth noting that recent legal rulings limit the use of hearsay evidence at this stage. The prosecution needs to present some direct or reliable evidence, not just hearsay, to establish a prima facie case. This gives the defense a chance to challenge weak or hearsay evidence early on. In practical terms, the preliminary hearing is a chance for defense attorneys to see what evidence the prosecution has. They can cross-examine witnesses and decide whether to challenge the evidence or negotiate a plea deal. Sometimes, if the evidence is overwhelming, the defense might waive the hearing to save time or negotiate better terms. But generally, it's a vital step to test the strength of the case before trial. So, to answer the question directly, yes, prima facie evidence is enough for a preliminary hearing to move the case forward. But it's a low standard, just enough to justify continuing. It's not proof of guilt. It's an early checkpoint that helps ensure only cases with some basis proceed to trial. And for the defense, it's an important opportunity to see what the prosecution has and to protect the defendant's rights early in the process.